Yes, Ms. Lee, good morning.
Good morning. May it please the Court, Mary Lee, Assistant District Attorney from the Plymouth District for the Commonwealth. This is a Commonwealth's appeal, and also the case is here on the Commonwealth's application for further appellate review. This is a nexus case on the execution of a search warrant, and the evidence as the result of the execution of the search warrant was suppressed in the Superior Court by Judge Locke, and then the appeals court affirmed that suppression. And the Commonwealth seeks this court to reverse those decisions and to allow this evidence to be used at trial, because we feel that the statement in the affidavit supports probable cause. Now, I think there's this temptation to look at this.
That's the statement that says that she goes to her home from time to time?
That is the statement of the defendant in the affidavit is what distinguishes this from the Pina Medina travel type cases.
You mean the confidential informant in the affidavit?
Yes, the confidential informant
I have
gives
a
a
question about veracity before we continue with the
Sure.
facts, which mostly sound like Pina to me, so we'll focus on this. I know that there's an assertion in there that this was somebody who had provided information that led to arrests and confiscation of drugs.
Yes.
Unlike most of these that I've read about, and I've only read about them in the appellate decisions, this one doesn't say when that happened. It doesn't say that cases were pending. It doesn't identify the defendants that were involved. It doesn't identify the courts or the case numbers. It's really thin about veracity, and you want to hang a very important statement based from the CI on someone who hasn't all that clearly been established to be
And that's the
someone we should believe.
Aguilar-Spinelli analysis. And in this Court's decisions, Commonwealth versus Perez-Baez, Commonwealth versus Byfield, says that the seizure of contraband is sufficient to establish the veracity prong of Aguilar-Spinelli. And so Perez-Baez is 410 Mass 43. It's a 1991 case. Byfield is 413 Mass 426,
Right.
1992. And so that, I suggest to you, would be sufficient even without listing off all the other background about that you have an affiant swearing this. I have used this informant in the past, as well as I believe he says 2 other identified detectives have used this informant in the past, and that person's information has led to the seizure of contraband. And I would suggest the case law under Byfield and Perez-Baez and their progeny would say that's sufficient. But if this court has concerns, then of course we have the 3 control buys.
Well, you also have, I mean, frankly, the CIA has provided you this information that this is a person from whom he buys heroin, and then there are 3 control buys that completely confirm both the method of operation and that this person does sell heroin on a pretty regular basis. Just call and you'll have a delivery.
Yes, through that phone number.
That the person participated in a transaction, or is the issue that the person is dealing out of the person's home? So
It's both. It's both.
Right. And in this case, there was only one time when there was surveillance that showed she left her home. And also,
I don't have direct travel there either on the origin.
That's right, or timing. There's some vague allusion to timing, but it doesn't really
I think there's
tell
a reasonable inference on timing.
It's within 5 to 7 minutes.
She leaves the house within 5 to 7 minutes. She's in the car and leaves the area. Surveillance stays at the house, the target location. He radios over. She'll be there soon to the people waiting at the sale location.
Right, but
And then it says
earlier than that, I think the phone call said she would be there in about 5 minutes.
she said she'd be there in 5 minutes. Exactly. And so I think from that, the reasonable inference is that location is not far from that area, but we don't have the exact time. It then says, surveillance says, then they call me and say the sale's complete. 2 minutes, she's back at the house. And she's inside before the surveillance car can even get up and see the car. He sees the car arrive, and he wants to go up and get a vantage point of her leaving the car. She's already out of the car. He confirms, however, that she went into the target location because the light goes on in the target location right after the arrival. He's turning his surveillance car around and heading back. So we have 3 returns. We have the direct returns, and then we have this 2-minute return I've just described. We have the origin at the target location in that we know she's there when the phone order is made. And I know that information was in the Medina case as well. I understand that, but I think that that also reasonably ties that location to these sales.
You suggest but never say that this is a landline.
I don't say that it's a landline.
No, you don't say.
I don't say that it's a landline. In fact, I think the inference from the affidavit is that it's a cell phone because he's using that same phone number in all the sales. He uses it in the control buys. I say he. We don't know the gender of the CI. The CI uses that same phone number. And that statement, in the course of the buyer-seller relationship, the defendant makes the statement to the buyer, and she sometimes makes the statement, I have to go home to retrieve the heroin prior to the meeting. So you know that they're not doing it face-to-face, and the communication is through that telephone. I think the reasonable inference from that affidavit is this is a cell phone.
But I'm sorry, did I misunderstand? Did you say that she said that sometimes, or that she said once that she sometimes?
No, she sometimes says to the CI that she has to go home to retrieve heroin
So this is
from the
multiple
apartment.
occasions, you're saying,
Yep.
that she has communicated that she has to return home.
I would suggest, yes. I would suggest the information in the affidavit shows that this is a buyer-seller relationship between the CI and the defendant. The CI does not know her real name and does not know her address, but says that their meetings are, and he says, CI says meetings at different locations, so we know that it's more than one prior sale before the control buys. They're on the south side of the city, leading the CI to believe that the apartment is somewhere on the south side of the city, and that is later shown in the, when they're following the defendant home on one of the return trips. They say she drives around the south side of the city back to her home, directly back to her home, and further, he calls her, the CI calls her Nana. The police confirm that is in fact the nickname that she has used in the past. So I would suggest what we have here, controlled buys by the CI, satisfy Aguilar-Spinelli. I mean, Commonwealth versus Cruz, you know, we have so many cases that say the control buys do it, and we have 3, not just 1. So I would suggest the fact that this CI was able to say the phone number, the street name, give her description, talk about her new car, which was black, nice and clean, and that she would show up south side of the city, different locations, and sometimes she says she has to go home to retrieve the heroin prior to their meeting.
Actually, could I just clarify that? It's not that the CI said a lot of times, said it sometimes. The CI stated that sometimes, Nana states. So I think the inference probably
Right,
is correct.
she's
At
not
one
saying-
point she said that
Yes, this defendant is not saying sometimes I have to get home. It's that, and I'll say it. The CI stated that Nana, that's the defendant, sometimes states that she has to go home to retrieve the heroin prior to their meeting. Now, I would suggest that the appeals court, as well as the motion judge, relied on Stegman, and the defendant relies on Sears and Silva, which are unpublished decisions that he's included in his addendum. And the motion judge also relied on Sears and Silva. He was the motion judge on Sears and Silva as well. And those cases are different. The reason they're different is because they don't establish the basis of knowledge that connects that statement to the apartment. In Stegman, the informant says one time the defendant cooked at the target location, and cooked the drugs at the target location. But it doesn't say how the informant knows that. In Silva, that's the bar case. Informant tells the police, defendant goes back to home to re-up, but doesn't say that the defendant told him that, doesn't say that he ever saw that. We don't have a basis of knowledge. Sears, you have 2 informants saying this defendant deals out of his apartment, but those could rise to no more than rumor based on the information in the affidavit, and that's where the motion judge is just plain wrong, and that's where, respectfully, the appeals court is just plain wrong. This isn't like Stegman and Sears and Silva. This is the affiant putting down exactly how this CI, who satisfies Aguilar-Spinelli, knows this information. How do we know where the heroin is? The defendant told us where it is. How do we know that's not stale? It was said clearly. The reasonable inference from that, I don't think there's any other inference you can take, is that was said during the context of the buyer-seller relationship between the CI and the defendant. And that buyer-seller relationship is a continuing and ongoing business. And that continuing ongoing business is shown through the 3 controlled buys on the 20th, 21st, and 26th. And I don't want to mislead the court. All of them say on or about, they use that approximate so as not to identify the CI. You don't want to burn the CI in your affidavit. And then the execution of the search warrant is done same day as the issuance, which is the 28th, so it's within 2 days. We don't have the staleness issue of Pina and Medina. We don't have the concerns that this information is stale, and I rely on Conley. You had a couple of weeks had passed in a year-long investigation. I rely on Cruz. That's 430 Mass 838, Commonwealth versus Melchidia Cruz. That was 6 buys over the course of 4 weeks. So the delay of a couple of weeks didn't create a staleness issue. Rice is the same situation. You have 15 months of activity, and so when there's some delay in an ongoing business, you see that kind of specified date isn't necessary. And so this is someone who's saying to the police, in the context of my buyer-seller relationship, sometimes, she says to me, she has to go home first. And so what the police did in this affidavit is they nailed down the veracity and reliability of that informant through the control buys, and they nailed down where home is. Because according to that statement, home is where the heroin is. And in that affidavit, there's no question that's her home. They have the Board of Probation records. They have her prior records with the Brockton Police Department. They have her, the police go into the common areas of the target location. They speak to the defendant, and she says apartment 3 is her home, and then you have the surveillance with the car parked there with regularity. And finally, that last sale, where she shows up 2 minutes after the sale and goes right up to her apartment. So that's home. She says home's where she keeps her heroin in the context of her business, and her business is ongoing. And the suppression in this case was wrong. The travel we have here, it doesn't have the origin direct from target to the sale. I don't think that's needed here. I mean, this is not a place where we want to have tick lists. Every drug case is different.
What inference can we make from the fact that she went from the sale on all 3 occasions directly home?
I think under Luthi and also the Escalera decision, which I realize is still in flux as this court is deciding your version of Escalera, but under those cases, you have that reasonable inference. I think it's a good inference. I think it supports probable cause that the proceeds are going to be taken up into the apartment.
Is this Rodriguez, essentially?
Rodriguez, yes, Rodriguez, a recent appeals case of Montero, which is still pending application of further appellate review. All of those cases say you have that direct travel back, and this is, 2 direct travels and 1 very quick and then right up to the apartment travel. I would suggest that she's going to be keeping at least the money there, but very likely the records of that phone, which she uses as her home phone as well, shown through her electric records. I mean, you're going to have her records, and you're going to have.
But I gather there's nothing in the affidavit which says that the bills were marked.
No, and that would be better. But again, this isn't a tick list kind of thing.
What do you mean marked?
If the bills were marked, I mean, some affidavits have it. If the bills were marked, then the police could definitely go back to that apartment and look for those specific 3 bills from the control buys. I don't have that, but we do have. She's a heroin dealer who's running an ongoing business. I think that's supported by the informant's prior history as well as these control buys, and she is apparently always going right back to her apartment. And so you'd expect the proceeds of her business to be there, and that would be Rodriguez and Luthi and Montero and Escalera, and I think those are good inferences here, particularly because that motor vehicle does not provide the security for keeping a stash or your proceeds. It's sitting on a driveway on Warren Avenue in Brockton, and it provides her no insulation from culpability because she has already been connected to that vehicle through a Brockton motor vehicle stop, and it's her mother's car, that was 7 months before. That's in the affidavit.
Again, what's insulation from having it in her home?
But you have more security in your home. And finally, I would just suggest the police should be able to search the place where the defendant says she keeps her drugs. It's highly probative. We don't have a basis of knowledge problem like in Stegman, Sears, and Silva. I would ask this court to reverse the finding of the motion judge as well as the appeals court and to deny the suppression in this case.
Thank you, counsel.
Thank you.
May it please the Court. John Redden, appearing on behalf of Mirangela Tapia. I think through the history of this case, we're pretty well focused on two basic points, which I can describe. Is this case different from Pina and Medina because of the number of controlled buys, number one? And secondly, whether or not this statement attributed to the defendant by the informant also distinguishes this case. Let me focus initially on the issue of the fact that there was 3 controlled buys here. I would suggest, based on Pina and Pina's endorsement of Smith, that the mere fact that there was more than one controlled buy in and of itself does not create a basis to distinguish this case from the results in Pina and Medina.
No, maybe not, but it certainly establishes that she is in the business. This isn't an idle one-off. She's in the business. Just call and it shall be delivered. A little bit like a pizza business.
A couple points about that. We get back to the basic proposition that being in the business, having probable cause to believe that somebody is engaged in selling drugs, still leaves us with the issue of whether there's a nexus. Just
well, of course, but so being in the business itself doesn't automatically indicate she's using her home, but
correct.
Any other evidence that suggests provides a basis to conclude she's using her home to facilitate the business in some way, either to hold the records, the money, the drugs, or an outpost. Why isn't that enough? And why don't we have that here perfectly?
It has to be a substantial basis to give probable cause. And obviously I think that's so because we're dealing with
probable cause. We're dealing with probable cause.
But there must be a substantial basis, the language of Pina in the cases. The question is whether these 3 undercover buys get you that. And I suggest it doesn't because historically it hasn't under Smith. Secondly, if you look at some of the cases that say a number of buys get you there, there's more involved. If you look at Escalera, I think there's four in Escalera. If you look at, I think, Hardy, there's a number of buys there. There's also another important feature to those cases that are not there. Inevitably, what you'll see in those cases, that aside from the undercover buys in and of themselves, there are police surveillances of the defendant in which the defendant is seen leaving his or her residence and going and engaging in numerous other street sales. I think Hardy, the term is, you mentioned numerous sales. There's another case, which escapes me right now, where the defendant is viewed going to Rhode Island, engaging into these very brief hand-to-hands with other people. Here, number one, there is not that. And it's not that there's not that because the police didn't try to get it. They conducted, aside from the undercover buys, 3 separate surveillances on 3 different dates. In 2 of those dates, according to the affidavit, they went back to the home multiple times during the day, looking to see if my client was leaving the home, obviously to see if she was engaging in these street hand-to-hand sales. They didn't ever see her even leave on one occasion.
So how long did it take her to do this last sale? 5 minutes off, 2 minutes back. 7 minutes in the course of the day, and she's made a sale. There's no indication the police had her under 24-hour surveillance. They stopped by to see if they could see her leaving and coming.
No, I think they were leaving to see if there was some evidence of her participating in this activity other than the sole deals to this informant.
Right. And so they stopped by to check, but this took her 7 minutes to conduct this transaction. We're not talking about leaving for half a day, and we're talking a couple of blocks away.
Well, we're not 100% sure, by the way, that it's 7 minutes, Judge, because there's an interesting gap in this affidavit that says she leaves and then she appears at the buy site. But very interestingly, it's specifically left out. It's exactly the amount of time.
It took her 2 minutes to get back from the buy site to her house.
Approximately.
Yeah, well, okay, 2.5, 1.5.
Right. We don't know.
So that's clearly very close.
We don't know how long it took her to get there. We do not have a direct connection.
Is it likely to take much longer to get from A to B than B to A?
We don't know because we don't know what she was doing. If she has a stash somewhere else, she could stop and get in the stash.
And the inferences we can draw from I'll be there in 5 to 7 minutes, or 5 minutes, I'll be there in 5 minutes, and she leaves her house 5 minutes after that. Okay. All right? She goes someplace, which is 2 minutes away.
We don't know that that's 2
Well,
minutes
it
away.
has got to
That
be
is
2
not
minutes
in the
away because it
affidavit.
only took her 2 minutes to get
We
back.
know it took her 2 minutes to get back, but we don't know how long it took her to get there. We do not know that she stopped at a stash. And that's one of the fundamental problems in this case, because unlike...
Can't we draw inferences if I say I'll be there in 5 minutes, it's probably pretty close, and she doesn't leave her house for 5 minutes, and then it takes 2 minutes to get back?
It's just as likely, Judge, that she had a stash somewhere that she could have stopped, but the police chose not to do a constant surveillance here. Nowhere is there a round trip made by her
Well,
under
surely if they had
surveillance.
done a constant surveillance, it would be almost proof beyond a reasonable doubt that she used her house, and that's certainly not the standard.
No, I think it would do away with the ambiguity and give you probable cause, which this affidavit does not give. For all we know, the only time she ever engaged in any type of activity is these 3 buys. There's
Well,
no...
no, wait a second. We have a confidential informant who I think has established reliability, who says, this is the person I buy from. And when I buy from her, she tells me to go to different locations on this part of Brockton, and sometimes she says, I got to stop by my home to pick up the stuff.
Well,
You may discount that, but there's no reason why a clerk magistrate looking at this affidavit has to discount that at all.
I'm not, just not me, Judge. An experienced motion judge discounted that, and a unanimous panel of the appeals court discounted that, because we don't know what sometimes means. We don't know how many times is sometimes, and we don't know when those sometimes occurred.
Why do we have to know all of that?
Because sometimes can mean also that sometimes she doesn't go back to her house, that she doesn't have it at her house, and we don't know when that was said.
But she doesn't have to go back to her house every time in order to establish this probable cause to believe she uses her house as part of her operation.
And but I think we need to know what that means. Does that mean once? Does that mean twice? Does that mean, did it happen 3 months ago, 4 months ago, 5 months ago? And here's an important point that I think we need not overlook, Judge. We have 2 very experienced narcotics officers, very well-trained officers. They are debriefing this informant before embarking on this investigation. And all they give us is that this informant said that the defendant supposedly states that sometimes she has to go home to retrieve the drugs.
Think about that.
Why?
It describes the person, the car she's driving in, all kinds of details about this, and says sometimes when I call this number that she says I have to call, she says I've got to go to my home to pick up the stuff.
We don't even know that that's coming directly from the informant saying that's what she told her or
That's
whether
what
she
the
told
affidavit
others.
says.
The affidavit says in these words, sometimes states that she has to go home to retrieve heroin prior to their meeting.
Right.
We don't know if this is direct to this person, if it's said to other persons. And again, we have no idea in terms of the temporal proximity of when that statement was made. We do not know when these prior supposed sales to this informant was made.
Does it inform us about the method and nature of her operation, which is ongoing?
We don't know that
Which
that's
is, if I'm
ongoing.
not home, I have to swing by home
We
to
don't
pick
know.
up
We
heroin.
don't know if that's the case when this occurred, and we don't know how long ago that was, and we don't know the frequency of it. We know none of that, and all of that, by the way. If this informant was capable of presenting this information, it boggles the mind that these experienced police officers would not have put that in the affidavit. Instead, they leave us with this cryptic remark, and now try to suggest that it has some significant temporal reference, which it does not. And I would suggest to the Court that that is a very, very flimsy read for the Commonwealth to place its hat on when they, the Commonwealth, are in control of what they're putting in this affidavit and drafting this affidavit.
What are you, I'm sorry, what are you saying that they, experienced police officers, could have said and didn't? What is it that they could have said?
Well, if this informant was able to provide them with evidence that this sometimes happened with a significant degree of frequency and happened at a point of time that was particularly relevant to this investigation, these are things that I'm suggesting to the Court. A police officer in debriefing this informant would record, and they would know to put it in the affidavit. But they don't provide that to us. They provide us only with this cryptic, unexplained reference in terms of when it happened and the frequency of when it happened, where she supposedly...
It's more than once.
It means more than once, but we don't know what it means beyond that. Maybe it means twice.
Do we know
Maybe
from the
it means
affidavit,
months and months
counsel?
ago. We do not know.
That's what I was just going to ask you. Do you know how long ago the statement
No.
was made, and do you know how long the defendant lived at her current address.
No, we know none of
There's
that.
some allusion here to that she was doing something with her mother at some prior time.
Well, the car was in her mother's name, I think, if I recall correctly.
So what are the alternatives here, pragmatically? The alternatives are that she kept it in her home, that she kept it in the car, that she kept it on her person, or that she had a stash house which she would go to before each deal?
Or a stash car. I've seen
Or a
that.
stash, I'm sorry?
A stash car, another car.
A stash car.
Yes, that's not,
All right.
in my experience, that's not an unusual method at all.
All right, but there was surveillance of her when she left the home. Now, of course, the stash car then would not be within eyesight of the surveilling officers then, so it's a stash car some distance away.
Well, it would be presumably out of the view of the surveilling officer who's at the home.
So she would,
So it wouldn't have to be terribly far away, I would imagine.
Wouldn't be this car.
No,
Would
no.
not be the.
No, well, no. By the way, they did have a warrant for this car.
I know.
All right, so, I mean, isn't a magistrate able to evaluate those probabilities and say, in view of the fact that at least at some point in time she said she had to go home to keep it, and in view of how little time she gave herself to get to the third controlled buy, which is I'll be there in 5 minutes, isn't the magistrate able to say that at least a likely source of it is her home? And isn't that enough?
I don't agree. I don't agree because we don't know what the sometimes is. We don't know the frequency. We don't know what came out of her mouth. There's no total round-trip surveillance observation here. There's not a close surveillance on her. It's not a surveillance that you see in other cases that's substantial. There's none of that at all. And then you have the fact that on other occasions when they surveil her, they have no other observations of her engaging in street hand-to-hands or anything like that. I think if you view everything in the totality, it falls short of probable
you
cause.
said earlier it's as likely as, I think you said in response to Judge Cordy, it's as likely as that she kept it somewhere else. Let's assume that's true. Isn't that still enough for probable cause?
No,
if it's as likely?
I think there has to be something to push it beyond the point of equipoise, to push it over the line, to say
Okay, but not
that
more,
it's
not more likely
probable.
than not.
Excuse me?
Not more likely than not.
No, but I think you have to be able to look at this and say it's beyond guesswork and it's beyond supposition, and gives us a substantial basis to believe there's probable cause that drugs are in the home. And I don't think this cuts it in terms of that test. I'd like to briefly touch on the issue of records, which has sort of emerged its head in this case. The cases that deal with the notion that there may be probable cause to search for records, invariably, if you look at those cases, deal with cases in which there's evidence of a large-scale drug operation. If you look at Luthi, it specifically mentions and keys on the notion of it being a large-scale operation. The same thing with Rodriguez, to my memory. And I think that's important, because I think it's reasonable to infer that when you're dealing with a relatively large operation, there is a likelihood that there would be records. If not for any other reason, the fact that Judge Locke pointed out in his opinion, the fact that many times people who are engaged in large-scale operations distribute drugs on the cuff, so to speak, on credit or consignment, and somebody needs a record of that. In this case, there's absolutely no indication of any type of large-scale operation. There's nothing to indicate that large amounts of drugs were sold. There's nothing to indicate that anybody else is participating in this operation. And there's certainly nothing to indicate any other customers other than the CI. And I would suggest that that distinguishes this case from those cases involving records.
Would it matter to you if the police had said, which I guess they did not, that they marked the bills for the controlled buys?
Well, that's an interesting point, and that's a little bit different than records. That, I guess, is proceeds, right?
Right.
But, yes, because otherwise what you have is, in terms of, is this evidential? Is it probable that we're going to find evidence? Just finding cash in somebody's apartment obviously is not evidence of criminality. We all presumably have cash in our homes to some degree. If it's marked money, that may change the issue in terms of this type of cash that's marked does have evidential value as opposed to generic cash. Although, frankly, I might question if it's marked money from a controlled buy, it probably is not going to have any evidential value at trial anyway. Reason being, presumably the government is not going to use the informant at trial. It's not going to introduce evidence of the controlled buy at trial.
Does the police have to commit to using the evidence at trial? I mean, it's certainly probable cause of a crime. The CI arguably could become a cooperating witness and testify.
In theory, Judge, that has happened, but in my experience, on very, very rare occurrence. So I think the notion that the fact that money may be back there is going to save it, I think disrupts it. Plus, I think if we're going to go that route, Pena and Medina fall. And are contrary, really, to the underlying basis of Pena and Medina. And I would say the same thing for phone records, Judge.
Did you guess Pena had marked bills? I don't recall. Did Pena have marked bills?
No, it did not. But if neither does this case. I'm saying if money's good enough, then...
Okay, but I mean, but there's difference between marked bills, which would be evidence of a particular transaction, versus cash in general.
True enough. As I noted, true enough, although I don't think that's that great, nor do I think the phone records are of any great significance either. Thank you.